40,000. That is the number researchers have derived from surviving probate records across 17 states. 40,000 living Americans declared legally dead by courts that never required a body, never demanded proof of death, never notified the person being erased that the proceeding had been initiated against them. Their property was redistributed to creditors and heirs while they were alive and working somewhere the courts had not looked. Their marriages were legally dissolved while their spouses were still breathing. Their children were reassigned to step-parents under surnames that had nothing to do with the families they had been born into. And when they came back, when the soldier returned from the prison camp, when the immigrant finally saved enough money to send for the family he had left behind, when the laborer made his way home from the territory where he had spent 3 years building a life that was supposed to be the foundation for something better, the law had no reliable mechanism for restoring what had been taken. The legal system that had erased them in their absence had no established procedure for acknowledging that the erasure had been a mistake. I found this while researching the dead letter office, following the trail of undeliverable mail that piled up in Washington by the millions every year. I kept finding letters addressed to people whose legal existence had been terminated while they were still breathing. Letters sent to addresses that now belonged to other families because the original family had been redistributed through probate proceedings that the letter writer had no way of knowing had occurred. Letters to men who had walked away from impossible debt and were working under different names in different states. Letters to soldiers whose families had stopped waiting after years of silence from prison camps that made communication nearly impossible. The mail arrived at the old address. The person it was addressed to no longer legally existed at that address or any other. And the letter went into the fire, as the law required. The official explanation for how this happened is straightforward, and at first glance entirely reasonable. American law inherited from English common law the doctrine of presumption of death. If a person had been absent from their place of residence and unheard from by family and associates for a period of 7 years, they could be legally presumed to have died. The purpose of this doctrine was entirely practical. Estates needed to be settled. Surviving spouses needed the legal ability to remarry without waiting indefinitely for someone who might never return. Business partnerships that had gone silent needed legal resolution so that the surviving partners could continue operating. The 7-year rule gave courts a standardized mechanism for resolving the genuine uncertainty that prolonged unexplained absence created. And in the era before telegraphs connected every corner of the country, before railroads made communication reliable, before any national registry existed that could confirm whether a missing person was alive somewhere, that mechanism served a legitimate purpose. That explanation is not wrong, but it describes the doctrine as it was designed, not as it was used, and the gap between how the presumption of death doctrine was designed and how it was actually applied in American probate courts during the second half of the 19th century is where 40,000 people disappeared from the legal record while remaining entirely present in the physical world. Here is what the surviving court records show when you examine them systematically rather than case by case. In 1857, the Illinois Supreme Court issued a ruling that the 7-year absence requirement was a guideline rather than an absolute threshold. Courts could presume death in periods shorter than 7 years if the specific circumstances of the case warranted such a presumption. The definition of circumstances warranting a shortened presumption period was left entirely to the discretion of individual judges. Within a decade of that ruling, similar decisions had been issued in Ohio, Pennsylvania, New York, and Missouri. The 7-year floor that had given the doctrine its practical legitimacy had become a suggestion, a starting point from which individual judges could depart based on reasoning that was rarely documented in sufficient detail to be reviewed on appeal. By 1880, probate courts across the country were processing presumed death declarations with evidentiary standards so minimal that the proceedings bore almost no resemblance to the careful adjudication the doctrine had originally contemplated. A sworn statement from 2 witnesses confirming that they had not personally seen or heard from the absent person within a defined period was frequently sufficient for a declaration to issue. No death certificate was required because the entire legal premise of the proceeding was that death could not be confirmed. No body was required for the same reason. No notification to the absent person was required because the court had already concluded, on the basis of the witness statements, that the absent person was in all probability no longer alive to receive notification. The proceeding was self-sealing in a way that made it almost impossible to challenge from the outside. If you were alive, you were not dead, and therefore you had no standing to contest a proceeding that declared you dead. If you were dead, you could not contest it. The only person with clear standing to challenge the declaration was the person the declaration had erased, and that person, by the court's own finding, was presumed not to exist. The people most vulnerable to this system were not randomly distributed across the American population. They followed a pattern that becomes visible when you examine the surviving case records across multiple states and multiple decades. Immigrants who had traveled ahead of their families to establish themselves in America before sending for their relatives were systematically overrepresented. A man who left his family in Eastern Europe or in an Eastern American city and went west to find work, intending to send money home while he built toward something better, was exactly the kind of person this system was most likely to erase. If the letters stopped coming because he had moved between work sites, because the postal infrastructure in the region where he was working was unreliable, because illness or accident had interrupted his correspondence for a period of months, a creditor or a landlord or a business associate with a financial interest in his estate could petition the court. The immigrant, laboring in a Pennsylvania coal mine or an Ohio factory or a Kansas wheat field, very much alive, had no way of knowing that a proceeding had been initiated in a court in the city he had left. No notification reached him. No summons was served. The first knowledge he had of the proceeding was when he returned home and found that the legal framework of his life had been redistributed to others. Soldiers generated the largest single category of these cases during and after the Civil War. The war produced unprecedented geographic separation between men and their families at precisely the moment when casualty record-keeping was least capable of tracking who was alive and who was dead. Hundreds of thousands of men were captured and held in prison camps where communication with family was nearly impossible for months or years at a time. The War Department's casualty records were incomplete, contradictory, and in many cases demonstrably wrong. A man listed as missing in action occupied a legal category that was technically distinct from a man listed as dead. But the distinction between missing and dead was one that probate courts were not consistently equipped or motivated to observe. Families who had received no word from a husband or son for 2 years were not acting in bad faith when they petitioned for a presumed death declaration. They genuinely believed the person was dead. The courts that granted those petitions were not acting outside their legal authority. They were applying the doctrine as the appellate decisions of the period had defined it. But the soldier who survived Andersonville or Belle Isle and made his way home in the summer of 1865 found that his family's genuine belief and the court's legitimate exercise of authority had combined to produce an outcome that destroyed everything he had returned to claim. His property gone. His family moved on. His legal identity redistributed to a proceeding he had never been told about, and no established legal mechanism for restoring what had been taken. Now, here is where it gets strange. When you look at who was actually initiating these presumed death proceedings, not who was nominally petitioning the court, but who had the financial interest that made the petition worth filing, the pattern shifts from the sympathetic to the troubling. Creditors filed a disproportionate share of the petitions in counties where the surviving records are complete enough to allow systematic analysis. Banks and lending institutions that held mortgages on properties whose owners had departed without paying their debts discovered that a presumed death declaration offered a path to the underlying asset that was faster, cheaper, and less legally contested than years of collection proceedings. A debt that might take a decade to collect through standard legal channels could be resolved through estate distribution in months if the debtor could be declared dead. The evidentiary standard for initiating the proceeding was low. The financial incentive for initiating it was significant. The person most affected by the outcome was, by definition, not present to contest it, and the legal system had no mechanism for notifying that person that the proceeding had occurred. Land speculation companies understood this arithmetic with particular precision. Between 1870 and 1900, tens of thousands of men left eastern cities and states for the territories in the frontier, drawn by the promise of land grants and new opportunities and the possibility of building something from nothing in a place where the past didn't follow. Many maintained irregular contact with family. Many lost contact entirely for extended periods as they moved between work sites and settlements that had no reliable postal service and no permanent addresses. Some intended to send for their families once they had established themselves. Some had simply walked away from obligations they could not meet. In either case, the pattern of absence was identical from the perspective of a creditor watching from a distance, and the mechanism for converting that absence into a legal declaration of death and then into a transfer of property was available to anyone with the resources to hire an attorney and the knowledge that the proceedings existed. The 1890 census was taken at the peak of this period. It would have captured, in the detail of its individual household schedules, the families headed by people whose first spouses had been declared legally dead, but were biologically alive somewhere in the country. The children carrying surnames that belonged to step-parents because the presumed death of their original parent had made the reconstitution of the original family legally impossible. The men living under names that were not their legal names because their legal names were attached to identities that courts in other states had declared no longer existed. That census was destroyed. The Dead Letter Office handled millions of pieces of mail every year addressed to people who could not be found at their last known addresses. Some portion of that mail was addressed to people whose last known addresses no longer existed for them, because those addresses had been legally transferred to other parties through estate proceedings. Those letters arrived at addresses where the original occupant had been declared dead, were marked undeliverable, and were burned as the law required. The documentation of who had been erased and how was itself erased in the same building across the same decades through mechanisms that were legal, routine, and designed with no provision for reversing what they had accomplished. Maybe the presumed death system was simply an imperfect solution to a genuine and difficult problem. Every functioning legal system requires mechanisms for resolving the uncertainty that prolonged unexplained absence creates. The alternative, freezing estates and marriages indefinitely while waiting for someone who might never return, produces its own injustices and its own complications. The courts were doing what courts are designed to do, applying available legal tools to situations that those tools were not perfectly suited for. But I cannot look at the pattern of who initiated these proceedings and who benefited from them without asking the question the pattern demands. The creditors benefited. The land speculators benefited. The second spouses who married into property that the first spouse had built benefited. Anyone with a financial interest in the estate of a missing person benefited from a system that required minimal evidence, provided no notification to the person being declared dead, and had no reliable mechanism for correction when the declared dead person turned out to be alive. The people who did not benefit were the ones who came back. 40,000 is the conservative number. It is derived from the probate records that survive in the states that preserved them. It does not account for the states whose courthouse records burned in the fires that swept through county seats across the South and Midwest during the same decades. It does not account for the territories that became states after these proceedings had already been filed and whose records were not systematically transferred to the new state archives. It does not account for the cases that were never formally recorded because the financial stakes were modest enough that the proceedings were handled informally. The actual number of living Americans who were legally erased by a system that was supposed to protect them is unknown. It has never been calculated, because calculating it would require precisely the documentation that the system was designed to not preserve. The courts that issued these declarations are still operating. The legal doctrine that authorized the declarations still exists in modified form in the statutes of every American state. The probate records that documented the proceedings sit in county courthouses across the country, mostly unexamined by anyone looking for this specific pattern. And somewhere in those records, in the estate inventories and the witness affidavits and the judicial orders that transferred property from the living to those who had claimed their inheritance, is the documentation of tens of thousands of people who came home to find that America had decided, quietly and legally, and without telling them, that they no longer existed. The law made them disappear. The law never developed a reliable mechanism for bringing them back, and the census that would have captured the full scope of what the system had produced was stored outside the fireproof vault in a building where destruction had been standard practice for nearly a century before the fire arrived. If you want more videos like this, make sure to subscribe to the channel. I'll see you in the next one.